Good morning, good afternoon, and good evening, depending on where you are. Thank you for joining Mayer Brown's Global Financial Markets teleconference series. Today's call is entitled Lenders Take Note: How the UK National Security and Investment Act 2021 could affect lending and debt restructuring. My name is David Harrison, and I'm a partner and co-head of the firm's European Antitrust and Competition Practice. First, one or two housekeeping items. As regular listeners will know, this call is being recorded. We will email an audio link to all participants in case you wish to listen to the teleconference again or forward it to colleagues. In addition, the recording will be available as a podcast. As we will not have a Q&A session, please send any questions regarding today's topic by email to gfm@mayerbrown.com and we will respond promptly. This email address can be found on your invitation. Joining me today is Mayer Brown partner Trevor Borthwick. Trevor is a partner and member of the firm's banking and finance practice. He represents banks and borrowers on large and complex financing arrangements, special debt situations and restructurings across a wide variety of sectors. With that brief introduction, we will now begin today's discussion. The UK National Security and Investment Act entered into force fully on the 4th of January this year. It represents the most significant change in the treatment of acquisitions of businesses and assets in the United Kingdom for many years. The Act, therefore, has a major impact on M&A. However, in this session, we will be focusing on its application to other types of transactions affecting financial institutions, such as lending and restructuring, including taking, holding, and enforcing of security over assets and shares. To set the scene, I will provide a brief overview of the new regime. Trevor will then comment on some relevant aspects of its application to transactions in the financial sector. The regime has two key aspects: mandatory notification and approval of changes of control of so-called qualifying entities that operate in any of 17 sensitive or key sectors, and a call-in power that permits retrospective review of other transactions, including acquisitions of assets. First, the mandatory regime. The scope of the key sectors is broad and is the subject of detailed guidance. They include, of course, activities relating to military and dual-use goods, but also include sectors such as advanced materials, AI, communications, data infrastructure, energy and transportation, just to name a few. A change of control occurs where certain thresholds are crossed, namely 25%, 50% or 75% of the shares or voting rights in a company. Importantly, there is a change of control if a person acquires the right to secure or prevent the passage of any class of resolution governing the affairs of a company. Therefore, if as part of a loan agreement, the lender acquires, for example, the right to veto the approval of the borrower's budget, this could constitute a change of control. Breach of the requirement of mandatory notification and approval is a criminal offence, and a notifiable transaction completed without the approval of the Secretary of State is void. Second, the call-in regime. This is broader than the mandatory notification regime in two key respects. First, in relation to entities, control includes material influence, a concept familiar from UK merger control. Determining whether material influence exists may involve a detailed facts-based analysis, focusing on the ability of the acquirer to influence policy relevant to the behaviour of the target entity in the market. Second, the call-in regime applies to acquisitions of assets, both tangible and intangible. As well as assets such as real estate, assets include ideas, informational techniques with commercial or economic or other economic value. Control of an asset means a right or interest enabling a person to use an asset or direct how it is used to a greater extent than before the acquisition. Outside the mandatory regime, the government can call in transactions to review for up to 5 years And there's also transitional call-in power for transactions entered into from publication of the bill on the 12th of November 2020 to the 3rd of January 2022. That power applies for 6 months until the 3rd of July this year. The government has published a detailed so-called Section 3 statement which outlines how the call-in power applies. It sets up 3 categories of risk: target risk, acquirer risk and control risk, and confirms that the call-in power applies to all acquirers irrespective of nationality. The government has said that the transactions most likely to be called in are those that involve activities most closely related to the key sectors. The regime is administered by a new Investment Security Unit, or ISU. Voluntary notification of transactions provides a means of mitigating the risk of call-in. The notification form itself is relatively brief, and there is no other specific procedure for consultation or informal guidance. For both mandatory and voluntary notifications, there is a 30 working day period during which the ISU must either issue a call-in notice, open an investigation, or approve the transaction. A full assessment may take up to 75 working days or more. The final decision could involve blocking or unwinding the transaction. There is also a power to apply for retrospective validation of non-notified transactions. There are a few other general points to bear in mind. First, extraterritoriality. The Act applies to acquisitions of control of entities outside the UK that carry on activities in the UK or that supply goods or services to persons in the UK. Likewise, it applies to assets used in connection with activities carried on in the UK or the supply of goods or services to persons in the UK. The next point is aggregation. Where a joint arrangement exists, the parties are each treated as holding all of the combined interests or rights. The joint arrangement exists if the way in which the rights are exercised is predetermined. The concept of an arrangement is no doubt deliberately imprecise. Something does not count as an arrangement unless it has at least some degree of stability about it. Other provisions relate to aggregation of rights or interests of connected persons and persons who share a common purpose. And there are also provisions on indirect interests, nominees, rights that are exercisable only in certain circumstances, and rights attached to shares by way of security. Trevor will refer to some of these. Lastly, the new provisions will apply alongside competition law and will take precedence where national security considerations arise. As in relation to merger control, early consideration will be key to managing transaction risks. Relevant considerations will include the impact on transaction planning, including in relation to the timetable and to gun jumping, that is, the need to avoid implementing a transaction that is subject to mandatory notification before obtaining clearance. And other relevant considerations will include the allocation of transaction risks as between the parties, for example, in relation to remedies and/or prohibition, and due diligence. A final remark relates to publicity. In general, the ISU does not publish information regarding the receipt and acceptance or rejection of individual notifications. In addition, the government does not routinely publish information about clearances or call-ins following the end of the review period, unless the parties themselves publish such information. An important consideration in practice may be the extent to which the target business is aware of an application for clearance, including the detailed contents of it, the impacts of this on any disclosure obligations, in particular in the case of a listed company, and any consequences for the target's business. Trevor will now develop some of these themes with specific reference to the financial sector.
Thank you, David. I'm going to look at how these themes apply in the context of 3 stages in the life of a finance transaction. The first of those stages is the entry into of the finance documents. In addition to the 2 considerations relating to the filing obligations of a borrower making an acquisition and acquisition financing, could the mere fact of entering into the financing be liable to a mandatory filing or the subject of call-in? In most cases, it's unlikely, but special attention is required, for example, if taking Scottish share security or English legal shares mortgages, because those forms of security transfer voting rights to the lenders at the start of the transaction. We'll discuss later on the slightly narrow protections in the Act for taking security over shares, but we'll also have to consider the material influence test that David referred to, particularly where there's a tight covenant package, including, for example, approval of a budget, which is rare but is not unheard of. In respect of assets, especially land, subject to security, lenders will also need to consider the question of the ability to direct or control how an asset is used, which David referred to earlier, since that may give rise to a change of control of the asset subject to security. The second stage I'll talk about is during the life of the financing. Could the simple occurrence of an event of default, for example, give rise to an obligation to file or the potential that a transaction could be called in at a later stage? The third stage we'll talk about is the enforcement stage or any restructuring of a transaction. The security agent or a secured lender could be subject to mandatory filing requirements or at risk of call-in at a later date if taking enforcement action, such as appointing a receiver, or if they exercise a right of appropriation in the context of financial collateral. Appointment of an administrator would not trigger a mandatory filing or be subject to call-in in the future because there are protections in favour of the administrator, but any sale by the administrator could be subject to those risks in the sense that a purchase from an administrator does not benefit from the protections afforded to the administrator. On enforcement in particular, the timing and process implications of the Act will need to be kept well in focus. In the context of restructuring, the same concerns as arise at the commencement of the transaction arise, but are enhanced, normally because a restructuring will include tighter covenant packages than a normal financing. For all of these stages, certain key factors need to be kept in mind, as David mentioned earlier. The question of whether there's a UK nexus, remembering that in certain circumstances, companies incorporated outside the UK could fall within the ambit of the Act. Does the financing involve entities or assets in one of the 17 sensitive sectors? And is the financing one of an acquisition of a company or of an asset, and therefore which tests within the Act are applicable? Looking at those three stages in a little more detail. When originally entering into a finance documents, lenders will need to consider whether the acquisition they are financing could be subject to the requirements of the Act. If so, what are the implications for their financing or their recourse to the target entity or assets if the borrower does not comply with the Act? And how can those risks be mitigated? For example, will a condition precedent requiring a filing, either voluntary or mandatory, and clearance before funding is required be included? In practice, given the current lack of clarity of the approach of the ISU, we expect that lenders will take a cautious approach initially. Clearly, where mandatory filing is required, we expect that to be a condition precedent to funding. But even in marginal cases, where future callback may be a risk, we expect lenders to require voluntary filing and clearance as a condition precedent to funding. Other considerations when making a new loan include whether the lender's own security should itself be subject to mandatory or voluntary filing. For example, as I referred to earlier, Scottish share security and English legal share security entail the transfer of voting rights in shares to the secured party on creation. There are reasons outside the Act why such a transfer may be commercially problematic, but if involved in security of the shares in the target of an acquisition, then the security may require filing, although we discuss later that there is some protection in the Act for this kind of security. If land is subject to security, the restricted covenants relating to that land in the finance documents will need to be considered carefully. Does the security give the secured party a greater ability than it had before the security was granted to direct or control how the land is used? If so, a filing may be advisable. The covenant package in some corporate loans could also trigger the need to file. Whilst unusual in the ordinary course of corporate loans, a right of lenders to approve a budget, which David referred to earlier as an example, has been seen in the context of other areas of competition law to provide material influence to a lender, and filing may be necessary. The Act does contain an exception for security granted to creditors, but that exception is limited and in practice would really only apply until most security becomes enforceable, whether or not the lenders choose to enforce. There are also limited exceptions available to an administrator and in respect of rights in favour of creditors, such as the right to enforce fixed security during the course of an administration. But those protections do not extend to the benefit of the purchaser from the administrator or to a secured creditor itself. Even where a transaction is not subject to mandatory filing, if the target entity or asset has a UK nexus, then any acquisition of control may be subject to the calling power, and lenders may always feel that a voluntary filing and clearance before completion is preferable, at least until there's greater clarity as to how the IC will apply the Act. Once a loan has been entered into, but before enforcement, lenders will need to continue to monitor the events and consider whether anything that occurs is likely to give rise to them obtaining control. Perhaps the most difficult issue here is that the mere occurrence of an event of default may have this effect, while the event of default is continuing. This is because of the way the exception in favour of secured parties in the Act is worded. Forgive me for reading out the Act verbatim, but it's important to understand what this says. The provision says that rights that are exercisable by a person only in certain circumstances, such as the right to enforce security, are to be treated as held by that person only when the circumstances have arisen and for so long as they continue or obtain, or when the circumstances are within the control of that person. Once an event of default has occurred, the rights that arise under a security document highlighted above are within the control of the secured party. More problematically, perhaps, if those security rights are granted in favour of a lender who has on-demand debt, then they are within the control of the person from the outset. So, in the context of a loan secured over a company's shares or an asset, it is possible that multiple occasions could arise where notification might be necessary or advisable to preserve lenders' rights, but could then fall away again as events of default are waived or cured. This cannot have been the intention of the legislators, but it is potentially the outcome or the effect of the Act. In the case of share security, the issue does seem to have been taken into account to some extent, because the Act provides that, and again, forgive me for reading out a section of the Act, rights attaching to shares held by way of security provided by a person, i.e. the grantor of the security, are to be treated as held by that person where, apart from the rights to exercise them for the purpose of preserving the value of the security or of realising it, the rights are only exercisable in accordance with the person's instructions. And where the shares are held in connection with the granting of loans as part of the normal business activities and apart from the right to exercise them for the purpose of preserving the value of the security or of realising it, the rights are exercisable only in that person's interest. So the Act is therefore saying that unless the secured creditor is actually enforcing its rights over the shares or enforcing its rights to preserve the value of its security, then the rights related to the shares are always in the hand of the grantor of the security. The problem with that language is that it is not always clear that some of the rights being used by the lender are being used to preserve the value of the security. Particular attention will therefore need to be paid to the terms of the share security that lenders take to ensure that this exception definitely applies, and that may give rise to other issues for lenders in a commercial context. Generally, lenders will need to consider how their event of default are worded to balance their desire to act before a problem situation deteriorates to become serious, with the risk of triggering a filing obligation at an early stage. When faced with a situation where enforcement or restructuring of a transaction is necessary, the Act will have considerable implications for both for the timing of the actions of lenders and for the steps and process that they follow. In particular, at every stage of either process, whether restructuring or enforcement, consideration will need to be had as to whether either an individual lender or an agent acting for the lenders should make a mandatory filing or a voluntary filing because they're acquiring control. Will it be necessary, for example, to await clearance before taking enforcement action? And what are the implications of that on the timetable of the process? In any restructuring, as opposed to enforcement, as I said before, all the considerations that apply when a loan is entered into initially need to be considered in greater focus, particularly as regards the material influence test that we talked about that earlier, because the covenant package in most restructurings is more restrictive than what we expect in the original loan. On enforcement, will a third party's purchasers need to make mandatory filing in order to ensure that any sale is effective, affect the timetable that lenders are working to? All of these considerations mean that the Act might well, in some cases, limit the potential pool of purchases for any company or asset which are the subject of security or an enforcement. The consequent implications of that for value realizable by lenders needs to be borne in mind and may affect the options analysis which lenders apply. Practically, if a filing is required either by lenders or potential purchasers in an enforcement situation, there will be timing implications for the process, and that timing impact may also affect the analysis of the liquidity needs of a distressed borrower, which will need to be factored in by lenders when considering their options. As between different classes of creditor in a distressed situation where clearance is necessary or desirable, allocation of the risk of clearance being denied could become a contentious topic, particularly where a sale process is being conducted against the objections of one or more classes of creditor. Similar considerations arise in respect of any post-sale calling of a transaction. As a reminder, an administrator is protected when taking control of the company, but receivers and liquidators are not, and nor are purchasers from the administrator. A complicated factor in all of the above situations arises where in syndicated transactions and deals where there's common security for different classes of creditor. Close analysis will be required as to which parties are required or would be well advised to make filings, and the answer to that question depends on who is entitled to instruct the security agent and who controls the enforcement process. That may require an analysis of the voting obligations in various documents. At this point, I'll hand back to David for a few concluding remarks.
Thank you, Trevor, and thank you to our audience for listening. A few brief reminders. You will receive an email with a link to the recording of today's call, as well as a short, quick reference guide to the Act. The recording will also be available as a podcast. Lastly, as mentioned before, if you have any questions related to today's content, please email them to gfm@mayorbrand.com. Thank you again for your participation. You may all now disconnect.